We could have a staff summary, please.
Thank you, Mr. Chair and members of the committee. For the record, Lena Langer, counsel to the committee. Second substitute Senate Bill 5974 concerns sheriffs, police chiefs, marshals, volunteers, youth cadets, specially commissioned officers, and police matrons. And as Chair Goodman mentioned, well, first, would you like me to brief the striking amendment in the line amendment?
It is in the books. Is that correct?
That's
yes.
correct.
Okay. So I have drafted a striking amendment, which actually addresses a number of the issues that I know people will be testifying, and including Sheriff Garcia. We're taking care of you. So yes, if you could brief the striker, please.
Okay, thank you. So also, as was mentioned, many of the provisions in the striking amendment are very similar to House Bill 1399, which this committee heard and reported out of committee last session. And for that reason, and in the interest of time, I will brief the major differences between the striking amendment and that bill as it was reported out of committee last session. So very, very briefly for background, eligibility requirements for police chiefs and marshals are specified in statute. State law requires elected sheriffs to complete a basic law enforcement training program, which complies with the Criminal Justice Training Commission or CJT standards within 12 months of assuming office, and the duties of sheriffs are also provided in statute. The background investigation required for peace officers, corrections officers, and reserve officers who have conditional offers of employment must include a criminal history and misconduct check, a psychological examination, and a polygraph or similar assessment, among other components. Turning to the striking amendment H3639.2, sponsored by Representative Goodman, eligibility criteria for sheriffs, police chiefs, and marshals are modified. Criteria that is different in the striking amendment from House Bill 1399, as it was reported out of this committee, are that the striker requires a person to have not been convicted of a gross misdemeanor in the U.S. or the equivalent under foreign law at any time, unless the conviction has been vacated, rather than have not been convicted of a gross misdemeanor involving moral turpitude, dishonesty, fraud, or corruption at any time. The striker requires a person to have at least 5 years of regular full-time law enforcement employment with a government law enforcement agency rather than 2 years, and requires a person to obtain certification within 9 months rather than 12 months of holding their position. Also different in the striker is that current sheriffs, police chiefs, and marshals at the time of the effective date are not required to meet the minimum age requirement or the requirement of 5 years of experience with a government law enforcement agency unless they seek appointment or election to a different office. A person seeking election as sheriff must submit a background investigation request to the Washington State Patrol or WSP within 6 months of and up to the filing deadline. If not yet certified, the WSP must complete the part of the background investigation that confirms that the person has met the eligibility requirements prior to the election filing deadline, or if the request is made too close to the deadline no later than the primary election. The WSP may wait until after the primary election for candidates who advance to the general election to complete the other elements of the officer background investigation. The bill, House Bill 1399, as it passed out of committee, required a person filing to submit the request at least 2 months before the filing deadline and did not provide the delayed timeline for the WSP to complete the background investigation. In the striker, the WSP must develop and provide on its website by October 1st, 2026, a standard form and process for persons filing for candidacy for sheriffs to use, including a form and process for the submission of fingerprints and other information necessary for the WSP to conduct the required background investigation. The county in which a person is seeking appointment or election as sheriff is responsible for any background investigation costs and must reimburse the WSP. As with House Bill 1399, some current duties of sheriffs and sheriff's deputies remain unchanged. A new duty is added and others are amended. Please refer to page 6 of the bill analysis for those. And the sheriffs and the sheriff's deputies may call to their aid volunteers and youth cadets rather than persons or power of their county as they deem necessary. Youth cadets are defined as participants in law enforcement agency training programs for careers in law enforcement. As with House Bill 1399, limits are placed on law enforcement agencies' use of volunteers. These sections refer to volunteers and youth cadets rather than volunteers and specially commissioned officers. A list of what the volunteers may not be authorized to do and what they may be authorized to do is provided on pages 6 to 7 of the bill analysis, and the permissive list is non-exhaustive. Additionally, agency agency policies must include limitations on the authority of and requirements for specially commissioned officers, including requirements that specially commissioned officers must be supervised by the law enforcement agency that commissioned them other than when supervision has been lawfully delegated to another agency, and require appropriate training for any firearms or other weapons that specially commissioned officers or youth cadets are authorized to use. And then finally, the line amendment to the striking amendment, Lang 197, sponsored by Representative Goodman, modifies when a vacancy is created in the office of an elected law enforcement official by providing that such a vacancy is created when the elected person has been decertified pursuant to a final decision, or if the eligibility requirements specified in statute have not been met or have not been complied with while in office, rather than providing that such a vacancy is created when the person is decertified, or if the eligibility requirements are determined to have not been met or have not been complied with while in office. That concludes my remarks. I'm happy to answer any questions.
Thank you very much. The chair recognizes Representative Burnett for a question.
Thank you, Chair Goodman. And it could be for the chair or for the staff, just confirming the disqualifier of it's still a gross misdemeanor.
Yes, the bill provides that a gross misdemeanor, if there is a gross misdemeanor, then the candidate is not eligible. And yet, if the gross misdemeanor is vacated, and that's what we provided, that if you just go ahead and vacate your gross misdemeanor, and then you're good. So that's the idea.
Right. The concern was that because right now a regular officer, line officer, is not going to be able to get terminated for a gross misdemeanor, and they'll get reinstatement back with back pay for like a DUI. And I know there was discussion on that, but I'll save that for later. Follow up for another question, or
sure. We just wanted to this issue of gross misdemeanors related to moral turpitude is sort of a century-old concept, and so we wanted to update that and say, just put a process in there. If there is a gross misdemeanor, go ahead and vacate it, and then you're eligible.
And then confirming backgrounds will be exactly the same for the other positions as the chiefs and the sheriffs on the bill? I mean, the marshals.
The eligibility requirements?
Yes.
Yes, those are the same.
Okay,
for
thank you.
police chiefs, sheriffs, and marshals.
As far as the background process.
Oh, the process. So there is a different timeline provided for persons who are filing for election for the office of sheriff.
I'm talking specifically to who and how the background check will be done.
Yes.
Washington State Patrol, not through their own city or.
Yes. They do go through the Washington State Patrol.
Okay, thank you.
And we have taken the CJTC out of that whole background check process. And yeah, they are the same, except we provide for the candidates for elected sheriff a greater timeline to get the background check done, even after the election. Okay, thank you very much. We welcome Senator Lovick, the champion of law enforcement issues and my best friend in the legislature. So please persuade us.
First of all, good afternoon, Mr. Chairman, members of the committee. For the record, my name is John Lovick, and I represent the 44th District in Snohomish County. And Ms. Langer explained the bill very, very well, and I really appreciate the strike of Mr. Chairman. I laid awake last night and read it, and I probably text you at 12:30. It's really done very, very well. So my remarks will be brief. Mr. Chairman, the legislation in front of you is about accountability. And when I think about accountability, I just want to set the best example that I think I've seen since I've been in law enforcement. The man sitting to your far right, he shows up and he has accountability, professionalism that this legislation aims to uphold. And if you look to your right, you would be looking at Sheriff Burnett. I still call him Sheriff because I had some great opportunities to work with him, and every time I went to any place with him, I saw the professionalism that he displayed. And I also spent a lot of time with former Sheriff Paul Pastor. And I know a lot of the men in this room possess those same qualities. So I just want to say that this is about accountability. And what I tell people all the time is that any person in leadership should be held to the same standards that they hold their subordinates to. And that's what this legislation is all about. I will occasionally not remember all of the great leaders that I served with, but I will never forget people like Sheriff Burnett and Sheriff Paul Pastor, the examples that they set for the communities that they served in. So with that, and I told you, Mr. Chairman, I had to sprint off to do something else. I appreciate you hearing the legislation. I appreciate your work on putting the striker together. I think it's done very, very well.
Thank you very much for taking the time to come over. I know you have to hurry off, so we're going to leave it at that because we have such a compressed schedule. We have to expedite through things. So thank you again. We're going to, needless to say, we've already given careful consideration to this bill, and we'll be continuing to do that. So
Have a good rest of the day.
thank you very much. We are now, the committee is now going to go into executive session. We are suspending the public hearing, and we will be considering two bills that are on the schedule for executive action. And let's ask the staff to brief the two bills. First, another bill by Senator Lovick, Gross Senate Bill 5068, and there is an amendment.
Martha Whaling, staff to the committee. Engrossed Senate Bill 5068 extends eligibility employment to persons legally authorized to work in the United States under federal law. There is one striking amendment in the EBB H-3621.1, sponsored by Representative Goodman. The amendment makes three changes. First, it provides that peace officers, city police, county sheriffs, and Washington Department of Fish and Wildlife officers are not liable for claim of employment discrimination if the agency rejects an applicant based on a determination that employment would be impracticable. Second, it amends the Criminal Justice Training Commission certification requirements to allow an application from an applicant who cannot possess weapons at the time of at the application stage but can possess a weapon if hired. And finally, it makes technical changes to the terminology for consistency throughout, and there are no other amendments in the EBB.
Thank you. I want to thank Martha for your exacting work in harmonizing and making the language uniform throughout the bill. Any questions? All right. The other bill we will be taking action on is Substitute Senate Bill 5855. Please, a briefing plus amendments.
As a reminder, Substitute Senate Bill 5855 prohibits law enforcement officers from wearing facial coverings while interacting with the public in the performance of their duties, with specified exceptions, and establishes a civil cause of action for persons who are detained by law enforcement officers violating the prohibition on facial coverings. There are three amendments, which I will brief in the order they are in the EBB. First, Lang 194, sponsored by Representative Griffey, adds a new intent section. Lang 195, sponsored by Representative Goodman, adds an additional exception to the prohibition on law enforcement officers wearing facial coverings for an officer utilizing personal protective equipment as required or authorized under the Federal Occupational Safety and Health Act of 1970 and the Washington Industrial Safety and Health Act. And then Lang 193, sponsored by Representative Graham, adds to the prosecutorial standards that prosecutors are strongly encouraged to prosecute crimes perpetrated against law enforcement officers, including but not limited to harassment and assault, where such crimes have a reasonable nexus to the requirement for law enforcement officers to be reasonably identifiable, and the prohibition on wearing facial coverings while interacting with the public in the performance of their duties.
Thank you very much. Are there any questions? Just wanted to comment on my amendment related to health and safety standards, both under, I'm going to violate my no acronym rule, WSHA and OSHA, WSHA on the state level and OSHA on the federal level. There had been concern from the State Troopers Association about the masks and helmets that you wear with your rapid deployment team. That is now covered with this amendment, and also any need to cover the face because of inclement weather and so forth. The standards under occupational health are very broad, so this will account for other use of facial coverings for health and safety purposes. We will recede to caucus just for 5 minutes because it's a very brief discussion here. We're just going to stand or sit here and whisper to each other, and you can do whatever. All right. So the committee will be in recess for 5 minutes. We're in recess.
Thousand metric tons of CO2 were actually reduced for that $4.3 billion that it's been raised. And